Erwin Sussman and several others founded a bank in Israel called North American Bank, or NAB. NAB collapsed after years of mismanagement, resulting in a morass of complex international litigation, including the Second Circuit case Sussman versus Bank of Israel. After NAB was liquidated, Bank of Israel sued Sussman in Israel, seeking more than $100 million in losses. Sussman counterclaimed, alleging that Bank of Israel had been negligent in its oversight of NAB. Sussman then hired an American lawyer, Nathan Lewin, to sue Bank of Israel in New York District Court. Before filing the complaint, Lewin sent Bank of Israel a letter claiming that NAB's collapse was due to Bank of Israel's turning a blind eye to misconduct by Israeli managers. He warned that continuing the lawsuit in Israel would deter potential foreign investors and suggested an out-of-court resolution. Bank of Israel refused to settle, and Lewin filed the complaint. The court dismissed Lewin's lawsuit based on forum nonconvenience, holding that Israel was the correct forum for this case. It dismissed the claims without prejudice and insisted that Israel accede to Sussman's demand that he not be detained should he travel to Israel for litigation. Bank of Israel then asked the court to impose sanctions on Lewin under Rule 11 of the Federal Rules of Civil Procedure. It argued that Lewin had filed the New York lawsuit for an improper purpose. The court found that Lewin's letter was intended to force the withdrawal of the Israeli lawsuit by threatening to sue in New York in order to cause negative publicity and economic damage to Israel. The court imposed sanctions of $50,000 on Lewin. Lewin appealed to the Second Circuit. He argued that his goal of pressuring Bank of Israel to settle the Israeli action wasn't an improper purpose, and even if it was, filing a complaint well grounded in fact and law can't be a valid basis for sanctions.